a short break. We are taking a witness out of order. Again, apologize for keeping you waiting, Attorney Imig. I saw you were in our lobby for quite a long time, so I thank you for sticking around. But we're going to begin with your testimony. I do need to swear you in. If you could raise your right hand. Do you solemnly, sincerely, and truly declare and affirm that the testimony you will give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
All right, you can put your hand down. And I can see your name on the screen, but could you just spell it and state it for me, please, so we have it on the record?
Yes, it's Courtney Imig, Kourtney, and my last name Imig.
All right, Attorney Formella, you can go ahead and begin with your questioning of the witness.
Thank you, Ms. Imig. And it sounds like it's a short I to begin the last name Imig, not long I, correct?
Do you want to move this microphone back over there?
Oh,
can you hear me?
I'm turning up my volume. If you could repeat that.
Yeah, let me readjust our microphone here. I just wanted to make sure it's your last name is Imig and not Imig, correct?
Correct. It's the first one.
Thank you. And what is your occupation at this time with respect to matter having to do with the subpoena that brought you here?
Okay. I work for the law office of Winter Law Office. And in my firm, we also represent the city of Antigo. So I am the assistant city attorney. I handle the prosecution of civil ordinances and traffic violations for the city of Antigo.
Yeah, how long have you been in that capacity?
Since March of 2020.
You are appearing here today pursuant to a subpoena that was served upon you. Is that correct?
That is correct.
And what brings us to your moment here at this proceeding is whether you've had an opportunity to review the disposition of a city of Antigo citation that I think is identified as citation number 337555.
Yes, I've had an opportunity to see that.
And I'm drawing your attention then to Exhibit C23.
Do you have the documents in front of you, Attorney Imig, or I can share it on my screen?
I do have them. I was provided it with a copy with the subpoena.
So thank you, Your Honor, and thank you, Ms. Imig. Looking then at Exhibit C23, I'm looking at the third physical page of that. It's also date stamped as Stewart 0123. Is that, so far as you know, a true and correct copy of a citation to Randy Stewart from 2010?
Yes, it appears that that is a copy of a citation.
Were you able to determine upon my inquiry what the ultimate disposition was of that citation and when it was so disposed?
Yes, based on the interpretation of the notes on the citation, it looks like there was a court date on July 27th of 2010 for an intake day. It looks like with the notes from the previous city attorney, that there during that time it was agreed that there was a 6-month deferred prosecution agreement, and that agreement was to be reviewed on February 15th of 2011, from the notes of that citation.
And when you're referring to notes, the handwritten notes, what I'm looking at is what appears to be handwritten notes at approximately the middle of that page. That's page Stewart -0123. Are those the handwritten notes that you're referring to?
Yes, the notes that say 6 months DJA until 2/15th of 2011 at 2:30 p.m.
Were you able to compare those handwritten notes with other records of an actual, other records that show a disposition through the Langlade County Circuit, Clerk of Circuit Court's office?
Yes, through my review of our records, and to inquire to make sure that that was the outcome. I verified with the circuit court in Langlade County, which indicated that this was dismissed on that February 15th of 2011. During that time, um, and typically that's why it is also not found on CCAP, which is the Wisconsin Circuit Court uh, website where it's known to the public where they can look at their information, that it dropped off because it was dismissed.
In part of your review of this matter, I would ask to turn your attention in with the court's understanding and Mr. Wistrom's of what I've marked previously as C27. I don't think, Ms. Imig, that you have something that's formally marked C27, but I will represent to the witness, to Ms. Imig, that it's first page of that exhibit is an August 26, 2021 letter.
And
from
I'm
the
showing it on the screen right now. This is what we received. It's C27, and then it, like he said, it's a letter dated August 26, 2021, and there's another document here as well.
And
Yes,
Judge,
I
for the
see that
record-
on our screen.
For the record, Judge, I would object to the introduction of C27 and that it was not produced in accordance with the requirement under DWD for witness and exhibit list to be produced 10 days in advance of the hearing. This was, I think, faxed to me yesterday or emailed to me yesterday afternoon.
What would you have done differently, Mr. Wistrom, if you had received it 10 days before the hearing?
I don't know. I may have had an opportunity to talk to Ms. Imig before the hearing here today.
All right. You can continue with your questioning, Attorney Formella.
Thank you. Ms. Imig, looking at the second physical page of C27, can you describe for this tribunal what that document appears to be?
It's a traffic court report.
And does it relate to the same citation that we identified earlier here moments ago?
It does.
And does this record, is this a record something that you have relied on, records like this in your course of your work as an assistant city attorney for dispositions of various cases, including this case?
Yes, if somebody requests records from our office and I try to be accommodating to provide the information that we have on in our office that we hold on to. However, this was a little bit different in where because of the dismissal of the citation, um, I couldn't view the records myself, so I requested that from the court to review the traffic court report records, and that is what that page is.
Okay, thank you for that explanation. Does this disposition shown on the second physical page of C27 comport or reflect the handwritten notes that you were just previously testifying on at Stewart-0123, those handwritten notes?
Yes.
And what is that again? What is the disposition? What is your testimony with respect to the disposition of that citation?
So the disposition of the citation, initially that this case was held open for 6 months and then it was dismissed based on the completion and successful agreement between the city and Mr. Stewart back in 2011, and it was dismissed. And typically in our procedure and process of how we handled deferred prosecution agreements, that lines up to what the traffic court report there represents as well.
In this instance, are you able to tell whether or not Mr. Stewart had to pay any forfeiture amount with respect to this citation?
He would have not had to pay the forfeiture of that citation because it was dismissed.
And in this instance, are you able to explain briefly the difference between a fine and a forfeiture? You know,
I guess the forfeiture includes court cost and um, other things that are associated with the fine of a citation under my understanding of what a forfeiture is.
sure, and I don't mean to be tricky about that. Is it fair to distinguish that a fine typically is used to describe a monetary penalty for a crime, whereas a forfeiture is a term that's typically used to define a monetary penalty for a civil ticket?
For a civil ordinance violation, yes.
And with respect to the dismissal of the citation, do you have an opinion then, based on your review of the records, whether there's any record that indicates that Mr. Stewart was ever convicted of a disorderly conduct event based on this citation?
Based on this citation, I don't believe that there would have been a conviction because it was dismissed on February 15th of 2011.
Thank you. That's all I have.
Do you have any questions for her, Attorney Wistrom?
Just a couple. So directing your attention back to C23, complainant 23, the third page. Got that?
Yes, I have it.
Okay, so the writing on that document, 6-month DJA until 2/15/11 at 2:30 p.m., that's not your handwriting, correct?
It is not.
And what is DJA? What is your knowledge of what that stands for?
It'd be a deferred prosecution agreement.
Why wouldn't that be a DPA?
I don't know, deferred judgment. There's two different, there's deferred judgment agreements and deferred prosecution agreements that people sometimes use interchangeably. Um,
But you haven't spoken to the person that wrote that notation on this document, correct?
Not that I recall, no.
And as far as the citation itself, it says deposit permitted, I think it's $389.50. Is that the fine amount that Mr. Stewart was initially fined as part of being issued the citation?
Objection to the term of use of fine, but
Okay, you can answer the question.
So it looks like that if the individual wanted to pay that citation without coming to court because it's not a mandatory appearance, that individual would have been able to pay that forfeiture amount and not have to come to court and conclude that matter that way.
And my version of this is very hard to read, but it appears where it talks about what defendant violated, it looks like an ordinance number. Is that 22.38?
It is, yes.
And is that a Langlade County ordinance or a City of Antigo ordinance violation?
It's a City of Antigo ordinance violation.
And then also checked after that is another box, and it looks like it's 947.01. Is that right?
That is correct.
And is that the state statute for disorderly conduct?
It is the state statute for disorderly conduct.
And a disorderly conduct citation under 947.01 is a forfeiture, right? It's not a felony or a misdemeanor.
Can you repeat that?
Yep. So a citation under 947.01 is listed or identified as a forfeiture as opposed to being either a misdemeanor or a felony, correct?
Yes, it's a forfeiture.
And when Mr. Stewart went to court in July, your testimony is that a deferred prosecution agreement was reached and that if he didn't have any further issues for 6 months, those charges would be dismissed, correct?
Yes, that's how I interpret the notes and the overall disposition of the case.
Okay. And in connection with that arrangement or that plea deal, Mr. Stewart was required to plead guilty to the disorderly conduct citation or forfeiture, correct?
No, that's not the understanding, or when you come to court, the plea would be a not guilty and the court leaves the case open for 6 months um, until the agreement is reached, and then um, they dismissed it. So I don't believe that a guilty plea was ever entered.
Okay. If you look at the last page of C27, please.
Just 1 second. Let me just switch over.
Toward the middle of that page, kind of above the line, it says disorderly conduct, forfeiture U, plea guilty. You see that?
I do see it.
Wouldn't that indicate that he did in fact plead guilty to the disorderly conduct citation?
I don't believe so, because I believe that would also reflect it in the notes and dates that have in the overall body in the bottom half, where I believe it says that he pled not guilty on 7/27 of 2010, which would then make sense of why they left it open until that February 15th date.
Isn't it true that typically in a deferred prosecution agreement, the person pleads guilty to the underlying charge?
No, they don't.
Do you have any explanation as to why complainant exhibit 27 indicates the guilty plea in the middle?
I don't have any explanation for that.
That's all the questions I have. Thank you.
Do you have any other questions for her, Attorney Formella?
No, thank you.
All right, thanks for your testimony, Attorney Ibig, and for again waiting while we took your testimony. So thank you.
All right, thank you.
All right, so then we'll go back to Mr. Stewart's testimony and where Attorney Wistrom left off. I'll remind you, Mr. Stewart, that you're still under oath to tell the truth.
Now, Mr. Stewart, exhibit 23, complainant exhibit 23, which is the document we were just looking at, which was a citation. Do you have that in front of you?
What number is that?
23.
Exhibit 23.
C20.
C20. First page, or what page is that?
The third page is the actual citation.
It's
Okay.
what we were just looking at with
Yep.
Attorney Imig.
Okay.
That appears to be a citation that was issued to you. Now, seeing the citation, do you recall receiving a copy of the citation?
I believe so, yes.
And despite the testimony of Ms. Imig, sorry, pronouncing that wrong, but you testified previously that you did in fact plead guilty to the disorderly conduct citation, correct?
Yes, I believe that was the agreement that I had to forego to it for it to be a deferred prosecution.
And your prior testimony that you believed it was 9 months, I'm sorry, 90 days, it was in fact 6 months that you were required not to have any further issues with law enforcement or with criminal justice system?
Yeah, that sounds right, yeah. Yep.
Now, I think where we left off is during your conversation with Ms. Verhagen, did you inform her either on March 6th or March 9th that you had forgotten about the citation?
I don't think, I think it may have been a couple days in another conversation where she brought that up. It may have been that phone call. I would have to look back in the notes to try to clarify that.
But you testified you had two conversations with Ms. Verhagen, correct? March 6th and March 8th?
I believe so.
Do you have any other meetings or conversations with her other than those two?
There was I don't believe so. There may have been. I may have spoke to her in person. I can't recall if that was one of those two.
Ask you this, during one of those two conversations you testified to about March 6th or March 8th, did you tell Ms. Verhagen that you had forgotten about the disorderly conduct citation until she mentioned it?
I believe, if I'm recalling right, I believe it was in person after that phone call where she may have mentioned that.
But your earlier testimony before we took the break was that on March 6th, 2019, Verhagen informed you about the disorderly conduct citation and the fact that it wasn't disclosed during the interview as being the reason that your offer was being rescinded. Correct? At that point in time, did you tell her that you had forgotten about the disorderly conduct citation?
During one of our conversations, I did say that.
And if you want to look back at exhibit number 13, please.
R13.
R13.
Page 2. Respondent's written response also confirms that I immediately told Tina Verhagen I had forgotten all about the disorderly conduct citation until she mentioned it. Read that correctly?
Yes,
So that would have been on March 6th when she told you about it, correct?
I believe so.
Now, toward the bottom of that page, in the next paragraph, you then write, when I was asked in my interview on October 19th, 2018, if there was anything I would like to discuss now, rather than have it discovered during the background check. If I had remembered receiving the disorderly conduct citation resulting in the successful completion of a deferred prosecution, of course I would have disclosed it just as I did the parking and registration infraction. Did I read that correctly?
Yes,
And that's a truthful, accurate statement?
yes.
You then write, I would never be dishonest with an employer or potential employer, especially knowing that any and all previous arrests and convictions would show up on respondent's thorough background check. Read that correctly.
Yes.
So you understood when you were asked the question in October of 2018 that your previous arrest for disorderly conduct would in fact show up on the background check.
Objection. Mischaracterizes what he just read.
Yeah, I don't think that's exactly what he wrote here.
Well, it may not be exactly, but that's my question to you. Did you understand that the disorderly conduct citation would show up on respondent's background check that they were going to do?
I did not know if it would or would not.
But you understood that all previous arrests and convictions would show up on the background check.
Objection. assuming facts not in evidence.
You can answer the question.
I'm sorry, can you repeat that one more time?
Did you understand at the time, back in October of 2018, that, quote, all previous arrests and convictions would show up on respondent's thorough background check?
Yes.
With respect to respondent exhibit 11, I think it was your testimony you never received this letter in the mail.
Yes.
Was there anybody else living with you at that address as of March 6th of 2019?
Yes.
And who else was living with you at the time?
My wife and children.
Who was your wife at the time?
Shanda Stewart.
Did you have prior issues with mail not being received or being delivered to you at that address?
No.
Can I have just a second, Judge?
Sure.
You can take a look at respondent exhibit 8, please. Judge, he's going to step out. There's some conversations in the hallway. We're going to tell him to try to keep it down.
Okay. Do you have exhibit R8 in front of you, Mr. Stewart?
I do.
If you look at the bottom of the pages, there's a number 2, 3, 3A, 4, 4A, 5, and it keeps going. So I'm going to direct your attention to page 8 and 8A. But first of all, have you seen this document before?
I'm sorry, the R8 you're referring to?
We're respondent exhibit 8, which is
Yep.
background check. And then the pages 8 and 8A. There's some handwritten numbering on the bottom right-hand corner.
Are you on that page?
Is it?
You're going to have to scroll through a lot.
8?
There's a number of pages because
Okay.
they're numbered. And then there's one at the bottom. There's an 8 with a circle. On top it says administrative.
Okay. All right. I have it now.
Okay. Have you seen or do you recognize this document?
I believe I can vaguely recall this. Yeah.
Okay.
I believe I've seen this.
Okay. And if you look at page 8A is a description of the incident involving the domestic issue between you and Jordan LeCue.
Yep.
And it says in the third line down, argument over living conditions and possible pregnancy, some minor shoving. You see that?
Yes.
Does that refresh your recollection as to whether there was some quote minor shoving?
I know she pushed over my motorcycle. I know she tried to come after me and I distanced myself. I don't know if I did no shoving. I don't believe I was shoved. But yeah.
Okay. If you want to look at Exhibit 12, Respondent Exhibit 12. Which is the complaint that you filed on page 2 as a narrative.
Sorry, on page 2?
Yep.
Yeah, where it's a statement of discrimination.
Okay. Yep.
Did you write that yourself? Or did somebody write that on your behalf?
I wrote that myself, well, in hand with my wife.
Okay.
Just collecting all the information that we had and then formatting it up like that.
Okay. But this is your summary of what your allegations are in this complaint, correct?
Yes.
And as far as you know, these are complete or at least accurate and truthful?
Yes.
And you reviewed this before you signed it on March 20th of 2019?
Yes.
Those are all the questions I have.
Do you have any redirect, Attorney Formella?
One area, Your Honor. Mr. Stewart, you were asked questions about contacts with Ms. Verhagen following or at about the time that you were being informed that the conditional offer was being withdrawn. My question for you is, did Ms. Verhagen ever ask you why you did not talk about the 2010 DC event at your October interview?
No, she never asked me why.
So if you spoke about that, those are that information that you provided to her was on your own initiative and not because she was asking you any questions about why you failed to say anything about the DC from 2010, correct?
Correct.
I have nothing further.
Anything else, Attorney Wistrom?
No.
All right. Attorney Formella, do you have any other witnesses?
No, I mean, I imagine part of my case will be built on cross-examination of county witnesses, but I'll reserve that for cross-examination.
All right. So then complainant is resting pending cross. It's about 12:15. Does anybody want to take a lunch break or do you want to just move into the respondent's witnesses and respondent's case?
Let me just go on mute here just for a moment, Your Honor.
Let me do the same.
Sure.
Your Honor, from our standpoint, we're thinking if we can break, for half an hour to 45 minutes.
So come back about 1:45, or are you saying 1:00?
Yeah, I mean, the court's discretion. Yeah, let's say 1:00 just to be round about it.
Okay.
Yeah, we'd maybe prefer a little earlier if we can come back in a half an hour. I guess we'll be back here and ready to go at 1:45, and if everybody else is back, I'd prefer to kind of keep things moving, but I think half hour from our standpoint is sufficient.
Let's try getting back at 1:45, but if it's a little bit after, that's fine. But let's try to aim for 12:45 to get back.
Okay, thank you, Judge. Appreciate
All
it.
right, thank you.
We're staying connected then, or how does that work?
What I've been doing is just telling people to mute and turn off their sound. I mean, you could leave, but then you're going to have the issue of reconnecting, and I don't know if the two of you want to go through that. So it's entirely up to you. If you want to leave and then just come back in, I can always let you in. But like I said, it's been on most of my hearings, it's been going okay, where if people just mute themselves and turn off their video, then we can't hear or see what's going on. And then when you're ready to come back, just turning everything back on, and then I know you're ready to go back.
See, it's not the command stopping video on this WebEx indeed just cuts the video. It doesn't cut the connection.
Right, yeah, I just saw your name pop up on the screen now. So I lost the video feed, but it said Brian Formella. So that's probably the easiest way of doing it.
Thank you.
All right, so then I'll see everybody back here in 30 minutes.